I still did it wrong. How many times do I got to do this and I messed this up? All right. Here we go. Okay. We are live from New York. It's Saturday night. Hi, everybody. Welcome. Thank you for coming here today. I'm very excited that you're here. And by the way, we've got quite the star-studded cast. Hi, Judy. Wow. Okay. Anyway, I am really honored. Thank you all for being here today. So we are at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and there's my telephone number. I'm getting a kick because I'm looking at my screen and somebody introduced me the other day as a juvenile delinquent. And I thought that was pretty funny because that's the JD part of things, right? It was a lot of work getting that credential, but I don't know if I'd do it again today. But anyway, I'm a juvenile delinquent today, otherwise known as a Juris Doctor. The There's my email address, easy way to get a hold of me. Let's take a look. I got some credentials, I guess, that make me qualified. I started my law class again. I've been teaching that at UCSD now for 25 years. Some people think I know what I'm talking about. So it's an ABA approved. I teach attorneys continuing education in real property law. So I guess maybe that'll be kind of topical for today. I am a broker in California. I'm a broker in Virginia. I'm trying to cover both coasts. Getting my broker's ticket in West Virginia. I've got people want to buy property there, and so I'm not 100% comfortable, but I'll do it. Anyway, in the meantime, as you can see at the lower left-hand part of your screen, I taught property management for quite a few years at the college level. But then I think more importantly, on the right-hand side are my risk management credentials. And I think that's kind of what I want everybody to be safe. I want everybody to be okay. And that's, again, that's why I do this is to hopefully help you and keep everybody out of harm's way. So I am still on NAR and California Association of Realtors risk management committees. Very proud to be part of that. And obviously I try to bring that information back to the local level as much as I can, and actually usually through these webinars. So I have, by the way, had my RPA class approved for by the Department of Real Estate. I've got 5 hours of continuing education approval that I can give that class. I'm waiting to get confirmation from San Diego because they always have first dibs at me. But in the meantime, I don't know, 5 hours, that's pretty cool, right? So that being said, we're going to be talking about things today that are going to appear to be legal. I always tell people, get the word legal out of your vocabulary. I wouldn't be doing that. I would, think of some other thing to call it. Hi, Stephanie. Wow, a couple times today. Thanks for being here. So legal law stuff like that, I don't get close to the line. That's what's kept me safe all these years. So I'm not a practicing attorney. I want to make that very clear. People introduce me as an attorney and I have to stop them right away and say, no, I have no interest at all. I think attorneys work awfully hard, and I know we make more money than they do. So and I have a tremendous amount of respect for what they do. So maybe that's why we get along so well. But I do a lot of trial work as an expert witness, mostly in the defense of real estate brokerages, standard of care for real estate licensees, agents' duties of inspection and disclosure, market conditions in San Diego County. Those are my specialties. Conversation today not intended to be a substitute for the advice of your broker. Absolutely not, nor for that of your attorney. Please consult with them as appropriate. Okay, so I know I'm going a little fast right now, but we have a lot to cover, and I don't think it's possible to do all of it, but I assure you it will be entertaining. And so thank you for being here. Talk today is intended to be interactive, so please ask questions, offer input by utilizing the Q&A button. It doesn't pop up like I think it should, but I do check it frequently to make sure. I know you won't be able to see the questions, but I usually repeat them so that you can know what it is that I'm looking at, and then I can go ahead and answer the questions so that everybody will benefit from it. So that being said, I do look forward to hearing from you. You help me to shape the direction of our talk, and I think that's kind of important because we're going to be talking about a subject today that not everybody does this. Now I know, Judy, I know you do this on the commercial level, but we're going to be talking today about the residential level of things. But all the same, two different worlds, by the way, and I do trial work in both. And it's like, it's just crazy what we do in commercial. So, so this morning we did open house success. I was very proud of that one. That was really cool. And I'm going to load that up to the YouTube for everybody to see if you want to go through another 2 hours with me today. But I thought that was a good one. That was kind of a game changer. Now we're going to talk about residential property management. We're going to talk about the beginning. So this class is not intended to make you a property manager. It is not intended to give you a credential towards property management, but it is intended to give you kind of a general outline of what you cannot do. So there's a lot of PowerPoint slides, but I really want to show you the forms, because the forms are what really is going to set us free here. Okay. So Thursday of next week. So nothing on Tuesday, right? Because hopefully you're all celebrating the independence of America on Tuesday, on the 4th of July. And I know it's a federal holiday. So we're back on the 6th of July, maintaining records, reducing risk. Again, one of my specialties. I'm hoping you can attend, but I've got some real cute little things to do to keep yourself out of harm's way. I was in a deposition not that long ago, and the opposing counsel said, they just kind of thought about it. They said, have you ever been sued yourself? And because I do a lot of trial work, but have you ever been sued? And I said, I had to think about it for a second. No, I haven't. I mean, and they, how did you do that? 44 years in real estate. And so I think you can do that too. I think that, you don't have to worry about litigation. I think you just take good care of people. And that's going to be the secret of your success. Excuse me just one second while I trying to get that fly for quite some time. And I think I got him finally. Okay. All right. And how often do you see that? And then in the afternoon on Thursday, we'll be doing all about disclosures. Okay, everybody good so far? Member benefits. So one of your benefits of membership at the San Diego Association of Realtors is that we bring the higher level of education. I mean, that's our whole goal. It is the key to success. And so thank you for joining us for our discussion of residential property management, the beginning. Okay, so let's talk about some key concepts here real quick. The first thing is, it is residential, it's not commercial. So that's what we're going to be talking about today. As a general rule, doing real estate related activities on behalf of another in California requires a California real estate license. And so I'm going to pivot on that just a little bit. You must have a broker's license or be working for a broker who does property management. It's a whole nother world. And again, we're talking about residential, and my job here today is to kind of give you the caveat of what you want to be careful about what you're doing. If you are working for a broker, then you need to make sure you have your broker's consent to do property management. I would get that in writing, okay, for your protection, for your broker's protection. All right. I don't think property management is really that difficult. I think property management is a good source of income. It seems to transcend changes in economy, things like that. People that do it tend to love it. If they do property management, they tend to only do property management. They'll do occasional sales. And frankly, part of that is because of the fact that they are, they're busy, right? When you're in property management, you're a systems person. And so I do counsel with a number of property management companies in San Diego County, and I can tell you they're busy all the time. They do sales, but when they do their sales, they do they do occasional sales, usually of the properties that they're managing. And so in property management, you tend to be dual agency. They tend to like that, but it's just kind of the way that things go. So again, remember, you must either be a broker or be working for a broker that does property management. And we're going to talk about some of the reasons why. If you have, and I've had people get brokers licenses, and I'll usually, they come to me and they say, I want to do property management. And I go, okay, well, I'll help, but what does your broker have to say? And they say, well, I got my broker's license. Okay, but are you still working for that other broker? And if the answer is yes, then you need to make sure you contact that broker and get something in writing from them that says that it's okay for you to do property management. They're almost always going to say under your own broker's license. So is everybody good with that? So as a sales associate, you work for a broker that does property management, or as a broker, you can run your own property management company. But again, if you're going to be a broker associate at another brokerage firm, you need to confirm with them that it is okay for you to do that. And again, get get that in writing. And I have that happen a number of times where an agent that has a broker's license wants to do property management and they want to stay with that original company. You need to stay there. Then make sure that they sign off on that they're okay with you operating your brokerage property management business as a separate entity. They typically will not allow no collection of rents in that office, in the office where you are a broker associate, right? If that makes sense. They don't want you using their address, don't want you using their phone number, don't none of that kind of stuff. Everything stays separate, and that's okay. I think that's okay, and I've permitted that on other levels with other brokerages where I've been the management at those brokerages, and we've had people come to us as a broker saying, I want to run my own property management company. Okay, but we don't know who you are. Do not put our logo on there. Do not put our information on that separate website, things like that. Is everybody okay? So a lot of the larger brokerages don't allow property management. Again, check with your broker before you start doing those activities. And I'm going to show you why in just a second. Okay, so let's talk about some key concepts. So for most real estate agents do leases. So they're leasing agents. Okay, and we're going to talk about the distinction between the two. Okay, so are you a leasing agent or are you a property manager? All right, and so what's the difference? Okay, so the leasing agent is once the keys are handed over to the tenant lessee, all right, it's over. Okay, so as a leasing agent, you can help the owner, with a contract, you can help the owner find a tenant for the property, perhaps talk to your broker about running credit, things like that. But the distinction is going to be that once you hand the keys over to the tenant, that tends to be that transfer of possession of the property, you're done. And so anything you do after that creates a problem for you. So you do not answer calls about repairs. You do not do repairs. You do not accept rent checks. You do not provide forms during the lease term. So you've got a listing agreement with a seller. You find the tenant. Remember, at the completion of the task, which means you found the tenant for the property, the tenant now takes possession of the property. You no longer have an agency relationship with the owner of the property. Okay, and so anything you do during that 1 year lease, for example, is going to be property management. And again, if your broker doesn't allow it, I'm going to tell you, be careful. You talk to your broker, tell your broker what you're doing. But I think that some brokers are going to be pretty firm about that. So we have a whole plethora of forms in the Zip Forms programs that, frankly, I think you may not use, and I'm going to show you in a minute. Okay, so it's kind of an interesting concept. But leasing agent, you are done. That includes you do not serve 3-day notices to pay or quit. You do not serve early termination of lease agreements. You do not serve any of those things. You are not involved in the process as a leasing agent. Is everybody okay with me? But I'm going to tell you, so after the keys are delivered, and again, keys tend to constitute possession in California to the lessor or lessee, and I'm using commercial terms, Judy, I know you understand this, you appreciate what I'm saying, but in commercial leases, the lessor is the owner of the property and the lessee is the tenant. Okay, all right, so I just use that, versus landlord tenant, and CAR has gotten away from the use of the word landlord because of for political reasons. They think it has a derogatory concept, so now they've changed landlord to rental property owner. So landlord is now the RPO, and then the agent handling any part of that transaction is going to be known as the housing provider, whether you are the leasing agent in this case or whether you are the property manager. Okay, so the property manager, now let's talk about that, typically does all of those things, all that stuff above that we all said. You may not do this, you may not, that the leasing agent may not do those things. Those are the things the property manager does. And so understand that there's a line between the two. And as I always tell you, listen, the biggest mistake we make is testing the water, right? I would not be doing that. You need to be checking with your broker on those things. Okay, so most all of our discussion moving forward here today comes directly from the California Department of Real Estate. Now, I love the DRE, right? I mean, I think we're in the same business. I think we're here to protect the consumer, and so everything we're going to talk about, and I'm going to quote them in a lot of different situations. Okay, so the California Department of Real Estate distinguishes between a leasing agent, a property manager, and then the casual property manager. And that's where it gets dicey. That's going to be that gray area that no person's land in between the leasing agent and the property manager. And so let's talk about that. What is the casual property manager? Well, excuse me. This is why I don't drink. The casual property manager is usually someone assisting someone else in procuring a tenant or providing services after procuring a tenant without their broker knowing about it usually. I mean, you've got to ask yourself, if your broker knew what you were doing, are they going to be okay with that? And of course, usually the answer, I was talking to a broker yesterday and I said, you got to stop telling me what you're doing, because the broker said to me, my agents are doing this, my agents are doing that. I said, those I don't know. I don't give legal advice, but I know that those are a DRE violation, but I think they're also criminal. And so he's telling me these things, and I'm like, you got to stop talking to me about this, because this is not good ground. So if your instincts tell you it's not right, it's probably not right. You definitely need to be talking to your broker. Everybody okay so far? So they usually don't have a written employment agreement, which means there's no, as a leasing agent, they can list a property to lease it. But as a manager, property manager, they have to have a property management agreement. And wait till I show you what that looks like. I mean, we just had the forms revisions on Tuesday. It was late afternoon Tuesday that they finally released the forms. I was so excited. I mean, it's on my calendar, notifies me, days ahead of time it's coming. It was supposed to get released on the 13th, but then they had to postpone it for 2 weeks. And anyway, I'm very excited. So I'll show you what's going on there. But watch out for that casual property manager. That's just somebody who thinks they're being helpful. And I always say, people just help themselves right into prison. And so, I wouldn't be doing that. Okay. So be careful about that. And we're going to talk, and I want questions. If you got questions, I want to talk to you about, what your concerns are. So always get your broker's approval before attempting anything that even casually resembles property management. Everybody okay? I've warned you. 63 slides later, I've warned you. And so as a property manager, you must either be a broker or be employed by a broker. Oops, let me check something. I hope I did not turn off the mic. No, we're good. Okay. Okay. All right. You must either be a broker or be employed by a broker that allows property management. Okay. And so, by the way, your E&O coverage typically does not protect you in property management. So check with your broker, because you want coverage on these things. It is a separate rider on an E&O insurance policy. I have one person right now who they're going to open up a property management firm, and they're doing a great job. I mean, they're going all the different, and they're a broker. They're doing all the things that they need to be doing. Obviously, I'm helping direct traffic on that. But it's surprising how inexpensive it really is. It's usually based on how many doors you have. So a door being a unit that you have in your portfolio. Okay, so it usually has an additional premium. I mean, I don't think it's going to change the world. I mean, if you're running like some of the really good guys out there, I won't mention. One was past president of SDAR, and I know he's doing 450 doors. So that's a lot of doors. And he would come talk to my property management class. And I love that guy. I mean, he is really good at what he does. So that's a lot of doors, but he's a machine, and he has a whole company full of people that do different things. So, that's where I want you to be. If you want to do property management, I want you to get to that. It won't be tonight. It'll be at some point in the near future. So property management is the most investigated entity by the California Department of Real Estate. Okay. All right. So, the top three, and I remember I got this from Wayne Bell, who was the previous commissioner. I really like him a lot. He's a great writer. But we're going to talk property management first. We're going to talk broker controlled escrow second. And then third, we're going to talk about hard money lending. Those were the top three investigated units. And so why is property management so highly investigated? And I'm talking about today. Well, why? Well, trust funds. right? So most of the brokerages in town that don't do property management have kind of closed down those trust accounts, right? Because trust accounts get us into trouble. Let me show you $6 million missing out of trust accounts. Okay, I'm not just talking about talking about people stealing money. I'm just talking about mismanagement of funds. Okay, and so perhaps having a good system in place would help. And the DRE likes that. If you've got a good system in place, the DRE will yeah. If you have no system in place, you're in the cooker. Okay, but if you have a good system in place, the Department of Real Estate, sometimes they can be helpful. They can actually help you fix the system if there is one. They're really good about that. But if you have no system, you're just doing this by the. I remember I had a complaint that I handled where the broker ended up, it's kind of a long story, but they had 6 agents, and one of them was doing property management, and they were aware of it. But and then unfortunately everything was going along just fine, and one day then that person passed away, and so unfortunately nobody knew where any of the money was, and so that's when things start to unravel, right? Tenants start looking for deposits, complaints get filed, things like that. You're just going to cook for that. So you can't. Ignorance is not an excuse. All right. So this is just the stuff that's missing, right? It doesn't include the monies that have been absconded with. So, we're not really focused on that. I mean, it happens all the time, but remember that anybody that handles any of the trust fund money must be bonded, insured. The Department of Real Estate is pretty clear about the requirements. And it's part of the license losing opportunity as well, that you allow somebody to handle that trust account that isn't bonded, isn't insured. Remember that trust account is the money of others, so it is in trust for others, and so it's a very serious thing. We're going to talk a little bit about commingling and conversion in a minute as well. So their position on property management, you must have knowledge of agency, contracts, fair housing, rentals and leases. Satisfies a considerable portion of property management requirements. Okay, so I always have to ask people, and again, this is not intended to talk you out of it. This is intended to have you understand what you're doing, what you're getting into. So again, I love the subject. Linda and I have talked about it. Since she got her license, I've always said not to do it, but now we're actually thinking about. I'm actually thinking she's clearly not. So I may have to open up my own property management company, but clearly under my broker's license, which I don't have a problem doing that, but then she doesn't want to get left out, the whole thing. So a lot of the stuff that you're looking at right there, I have to ask you, don't you have this knowledge already as a real estate agent? I mean, think about it for a second. All those things we just talked about, you already know you're responsible to know those things, and I know we all have doubt because we don't know it, we need to know it better, that kind of thing. I'm hoping you don't get 44 years into real estate before you start to understand it. And most of you are much brighter than I am, but what's that old story about education, then knowledge, then wisdom, right? Judy, I don't mean to be picking on you today, but you're a good example of somebody I think knows what they're doing. So, okay. All right. So additional knowledge for property management is required. All right. And so in business administration, this is straight from the Department of Real Estate. All right. Business administration, marketing, purchasing, extensions of credit, accounting, accounting. I want to pause on that for a minute, right? Does that have anything to do with trust funds? It absolutely does. Now, in some cases, the property manager may want to delegate some of this to someone else, right? And there's a lot of companies out there, good ones out there, that'll take care of your accounting for you, take care of your books for you, things like that. Ultimately, if you're the broker, you're the captain of the ship, you are responsible, but your accounting is going to be very important. I don't know how to use, I'm sorry, I know a couple of ways to use Excel. I am not an Excel expert. I am going to farm that out to somebody else. I'm going to have someone who is bonded, insured, somebody that I trust that'll handle it. And because we're going to get audited, right? You're going to get audited. I have a very good friend up in North County. Her name is Marie. I won't tell you her last name. Wonderful lady. Runs, decided one day she didn't want to do sales anymore. She wanted to do property management. And she says, we get audited every 2 years, and it becomes just a way of life. We know they're coming, right? And it's okay because they come in and they tell her, okay, you need to fix this, you need to fix this, you need to fix this. And she says, we go ahead and do it. Everything's okay. There's no public reprimand, none of that kind of stuff. We're not running away with people's money. We're keeping good tabs on things, stuff like that. This is a very doable thing, all right? A very doable thing, okay? And I don't think it's that tough, but you've got to be a good systems person. And so, you get your systems in place, the program almost run itself. Your job is to go out and talk to people, make nice, and find tenants and find owners and things like that. All right, so advertising, insurance, repairs and maintenance, taxation and public relations, all of this stuff, easy to handle. You don't have to be an expert, but you should probably aspire to be an expert in some of these things at some point. And again, as always, I will help you if necessary. Not in my position as I am here right now. Let's talk about some professional organizations. So we do have some professional organizations out there that you really should be considering a membership in them. Okay, so and these, by the way, are also the Department of Real Estate's got them right up on their website. So the Institute of Real Estate Management, otherwise known as IREM, you'll get really good with that term. Individuals meeting the educational experience requirements are designated as certified property managers. That's going to be my CPM designation. I think some of you here today have that designation. All right. And a lesser degree of training and on-site experience qualifies an individual as an accredited residential manager, an ARM. A firm that meets IREM's guidelines and utilizes at least one certified property manager can be designated as an accredited management organization. The practices and the discipline involved in these associations are recognized by the Department of Real Estate. And I think, interestingly enough, there is no separate real estate licensure for property management. I don't know that it should be required. I know that CAR has gotten into creating, courses for it and designations for it, but I think that again, people that usually do property management do only property management and then occasional sales. So there's also NARPM, so the National Association of Residential Property Managers. They offer professional designations, so the RMP, the Residential Management Professional, the MPM, the Master Property Manager, and the CRMC, which is the Certified Residential Management Company for firms that manage single-family homes. They also have the CSS, which is the Certified Support Specialist for support staff, people that work in the organization. And so we're going to talk. So those are some of the big designations, some of the big groups that you're going to probably become a member of. Let's look at property management itself. There are 3 different types of property managers in the eyes of the Department of Real Estate. So there is the individual property manager, there is the individual building manager, and we're going to break these down into their component parts here in just a second. And then there's the resident manager. So the individual property manager is the real estate broker who manages properties for one or more property owners. That would be the more common, a broker handling the properties of others. Again, the day-to-day operations, they do take the phone call about the broken water heater. They do go and look for carbon monoxide detectors and things like that in individual residential units. The individual building manager may be employed by a property manager or directly by an owner, and usually manages a single large property. So, a 64 unit apartment complex or something along that lines. They're usually in 16s and 64s, and they can get much larger than that. And then finally, the resident manager may be employed by a real estate broker. They may also be a broker. A managing agent may employ them. Again, these are employees, or an owner to manage an apartment building on a part or a full-time basis. And again, that's usually the resident manager doesn't necessarily have to have a real estate license, but they're working for a company that owns the building, but they're working as an employee. Okay, that's different. Remember, that's the person who, if they don't have a real estate license, they can't get out of the office, go across the street, and show a property across. Well, I'm sorry, they can, but they may not show a property across the street because they don't have a real estate license. If they have a real estate license, that's fine, but the company that they work for needs to be aware and authorize them to be able to do other properties other than the resident management of the one single building. Okay, everybody good with that? All right. The property manager has a dual responsibility, right? So to the owner or client who's interested in the highest return from the property. And again, we're going to talk about the rental property owner, and there is no client until you have a written agreement. That's the law. That's how that works. All right. So you a property management agreement, which we're going to look at in just a minute. All right. And to the tenants who are interested in the best value for their money, including reasonable safety measures and compliance with fair housing laws. And so that's a huge statement, right? I mean, we have, a warranty of habitability. They're going to lease a property. They have an expectation that the heater's going to work. And so there may be an issue of warranty of habitability if it isn't. By the way, there is no warranty of habitability for air conditioning, but there is one for heating. So, okay, I don't know. I guess that's not a double standard, but it just is what it is. Other things like, the property must have a bathroom, a commode, things like that. If you've only got one bathroom in the place and it's not working, there's some things that happen where the tenant can perhaps withhold rent. In some states where I teach, they literally have to continue to pay rent, but it goes into an escrow account until the owner fixes it. So anyway, compliance with fair housing laws, that is a huge issue. And so I'm going to talk to you about some things on that in just a second. Here are some of the specific duties a property manager must perform in the eyes of the Department of Real Estate. And there's quite a few. Establish the rental schedule that will bring the highest yield consistent with good economics, word for word, all right? Merchandise the space and collect the rent. Again, property manager, all right? Create and supervise maintenance schedules and repairs. If applicable, ensure independent contractor license status and insurance coverage. Now, most of the property managers that I work with have employees. Very few of them have actual other real estate licensees, but if they do, then the rules apply equally to those other licensees. Okay, so if they have a licensee acting as a salesperson versus as a office staff, then they're going to end up having to join the Association of Realtors, get their status, assuming that the company is a realtor company, and they would be independent contractors for that purpose, but they would be employees for purpose of working within the firm, okay, on the company's properties. Okay, set up payroll system for all the employees, develop a tenant-resident relations policy, supervise employees and develop employee policies, including an injury prevention plan, and maintain proper records, make regular reports to the owner. And we'll talk about what periodic reports they would make, qualify and investigate a prospective tenant's credit, prepare and execute leases, obtain decorating specifications and secure estimates, hire, instruct, and maintain satisfactory personnel to staff the building or buildings, audit and pay bills, advertise and publicize vacancies through selected media and broker lists, recommend alterations and modernization as the market dictates, inspect vacant space frequently. I find this not happening on the residential side of things, where agents are listing properties that they're the leasing agent versus the property manager. And I find the vacant places sitting for periods of time and nobody's overseeing, making sure the water's still turned off, that people aren't turning water on, the lights are out, things like that. So they're pretty serious about this. Keep abreast of the times and competitive market conditions. Why? Because you're constantly in a state of flux. Your market's going to change. I was making a comment in a talk I was doing in Virginia this morning, the market's changing while you have the listing. And so, you need to be constantly aware of what's happening in the marketplace. Obtain and pay insurance premiums and taxes. In some case, paying those, obviously paying those not only for your company, but also paying them perhaps for the rental property owner. And we'll talk about that in just a second. I really like the new property management agreement. I can't wait to get to it. So be knowledgeable about and comply with applicable federal, state, and local laws. And then what other specific duties? You report to the owner. Property manager must set up and maintain proper records. That's usually the kicker. Making regular reports to the owner that are easily understandable, that cover all the operations. Remember, the owner of the property is saying, you handle it, Roy, and just send me my check, right? So I'm going to talk to you in a minute about who gets paid first in the field of property management. It's also recommended the property manager provide not only a monthly accounting to the property owner, and I think that's for the safety of the property manager as well. Your books need to balance to zero at the end of every month, and so if you're not monitoring them but once every 6 months, there's gonna be issues. Okay, so you have to have a net zero at the end of every month. And again, there's that trust account thing, and we'll talk about that again in a minute, but also a detailed annual statement, right? You must do this. Again, this is not an onerous task. We have software in place for you to be able to do that, right? But again, as some of you are aware, that the California Association of Realtors has taken all of their DRE trust fund documents and removed them from their library, and instead they're referring people to go to the DRE's website. And I'm going to show you that in just a second, where a lot of that information is there. I think it's good for the person starting out, but I think at some point you're going to have more. The trust fund accounting for sure. The DRE is telling you this is what we want to see. I'd probably be using those documents, right, to maintain your records. But some things you're going to probably have to go up a level and maybe have counsel take care of that. By means of annual statements, the property manager can assess the fluctuations of income and expense and to formulate future rental maintenance and employee policies. I think those are good things. DRE requires that all property management agreements be in writing, right? We call it the statute of frauds. It's English, comes from English common law. And it says that first of all, in order for you to be employed, you have to have your agreement in writing. The DRE does not allow us as real estate licensees to have casual oral agreements. Some oral agreements can be binding at law. Again, contracts is a year of law school, okay? So we don't want to do that today. But just understand the Department of Real Estate makes it very clear that they want all of our documentation to be in writing. And part of that is to be able to defend ourselves, but part of that can also be Exhibit A against us at trial, okay? So we're going to talk about that in just a minute, all right? Clearly setting forth the responsibilities of both of the parties, all right? Now we're talking about the property management agreement. So who's the property management agreement with? So this is actually a DRE test question on the state exam. I asked to be able to, they were asking for people to get on the task force of the Department of Real Estate to help update the real estate exam. Okay, so aren't you glad you have your license? They're going to be updating it. They wouldn't let me on because I was just teaching the crash course. I thought it was within less than a year, and they said we can't use you for that. But I think it's maybe been a little bit more than a year now, so I can get on that one, because a lot of stuff I'd like to see different on the state exam, but more relevant stuff. Okay, so anyway, again, your agreement has to set forth the responsibilities of both of the parties. That would include the terms and period of the contract, of course, right? The policies pertaining to the management of the premises. Okay, remember what I always say, when you define your duty, you limit your liability. So we want to define our duty, and that's what the agreement does. And rather than, well, don't worry about it, I'll take care of it, that's definitely not going to be a good answer, okay? Management fees, if any, you're going to be surprised what the property management agreement allows you to charge. I mean, again, everything's going to be negotiable, but there are things that we don't think about sometimes, like, well, we've got to do an eviction, and so I've got to prepare for the small claims court. I've got litigation preparation to do, things like that. We often think that it's just included in the price we get, but a lot of companies are charging extra for those services. Okay, so again, dollar amount, a percentage of expenses, whatever. All right, so the authority and powers that are given by the owner to the agent. Okay, the agent, I should have had that in uppercase A. DRE doesn't think of it that way, but the uppercase A is the agent, the broker. Remember, the big A is the broker for the company. Okay, so the broker of record. All right, the property manager is subject to all of the legal restrictions generally imposed upon an agent. as well as those specifically included in the contract. So you have this set of stuff that the DRE is going to say you're responsible for, and then you might be binding yourself to more stuff in the agreement. And I think that you are. So when we look at the property management agreement, I'm trying to go over the property management agreement and the lease listing agreement with you here in just a couple of minutes. Such obligations include good faith and loyalty. Okay, that's the definition of fiduciary, essentially, right? Fiduciary duty. Performance of all duties with skill, care, and due diligence. Full disclosure of all the pertinent facts, material facts, okay? Avoidance of commingling of funds. And so I promised you I would talk about that. So what is commingling of funds? So the Department of Real Estate allows you to put $200 of your own money into the trust account. And that is for the purposes of handling bank charges, bounce checks, things like that. So $200 of your own money, not a nickel more. All right. If you put in more than that, then it becomes commingling. That means you're mingling your money in with the money of others, and that's a big no-no. So I remember being in a meeting with the Department of Real Estate sometime a couple of years ago now, and they said they got a license renewal check from a broker, and the check bounced. Now, if I was going to bounce a check, I would not be bouncing it to the Department of Real Estate, right? But this broker bounces a check to the Department of Real Estate, and so they look at the check, and they go, "Oh wow, they wrote the check on the trust account." So now think about this for a second. You wrote your license renewal check on a trust account. Okay, first of all, now that's called conversion. You commingled somehow. Well, maybe not. Maybe you didn't commingle because the check bounced. So there wasn't enough money in there, and your license renewal as a broker is clearly more than $200, right? And so maybe you didn't commingle. Maybe you only had the $200 in there. The problem was that the issue of conversion is you use somebody else's money for your gain. So in other words, here's the department. They've got a bounce check from a broker for a license renewal, and it was written on the trust account. So it was interesting because the commissioner made the comment. They said, we didn't even bother calling. Normally we call, tell you we're coming. And he said, no, we just sent a whole bunch of guys down there, a bunch of special investigators, they call them. And like I said, I have a tremendous amount of respect for the Department of Real Estate. But they said, we marched into the office. We said, let's see your books. And during the course of looking through the books, they found that this broker had been paying for their own personal landscaping fees and electricity bills and things like that. And so the investigators said, well, how did you not run out of money? And apparently at one point they did, because they bounced a check to the Department of Real Estate, said, oh, I just put more money back in there again. So this person was putting money in and out of the account. There was clearly no separation of money between the client's money, remember, money held in trust for others, and the $200. So once you start spending money out of the account on your own personal stuff, we don't know which one is yours and which one belongs to the client. And that's one of the big problems in the issue of conversion. Okay. And so again, some legal principles clearly on the state exam. All right. So they're going to ask you those things on the state exam, but you want to avoid commingling. Clearly, you don't want to do that. Oh, by the way, in that story, the commissioner said, we just took the license. He said, that's like, I don't think I would have argued with him a whole bunch about it. I don't think that was very bright. So anyway, bottom line is, do not put your money in with the money of others, subject to that $200 limitation. You should be okay, but you better be good with accounting, okay, if nothing else. All right. And so, I know some people that are really good with systems and things like that. They make really good property managers. But again, anything you can't do, you farm that out to a reputable entity to do that for you. So refraining from personal profits, and again, that may be the reference to conversion, without the principal's full knowledge and consent. So did they know what you were doing? Did you have permission to do what you were doing? And we're going to cover a lot of that in the property management agreement, which, by the way, this is not a forms class, but we are going to spend a little bit of time on it because I want to show you the highlights of that. The agent must be familiar with the laws concerning real estate licensing, because you're going to end up hiring people to assist you in what you're doing. Contracts, agency, again, fair housing, fair housing, pretty big subject in property management. Employment, property protection, insurance, and tenant landlord relationships, or tenant rental property owner relationships, or housing provider relationships, as we're calling them now. So I'm sure at some point tenant won't be an acceptable word anymore either. We'll have to come up with something. I like lessor and lessee. I like that because I'm just used to it. But all right, fine. Excuse me. The DRE publishes many guides to protect tenants, and I'm just going to show you a couple of them. I think it's really not comical, but I'm going to show you what. So they've got the landlordtenant.dre.ca.gov, and again, everything I talk about today, I'll send it to you if you want it. The webinar I will upload because I was just sending these huge packages, and the webinar is obviously an MP4 file, so I'll just load it up onto the YouTube website. You can grab it off of that. But this is one of the websites that they provide tenants, right? So the California Tenants Guidebook, there's a whole reference book, the REF 09, Knowing Your Housing Rights fact sheet. All this stuff is geared to protect the tenant and to inform the tenant of their rights. The theory being that it's the innocent tenant and the big bad landlord. I'm not aware of any guide that the DRE publishes to protect the rental property owner or the housing provider. I don't know of any, right? But I think the whole system is geared to protecting you by actually creating the rules for you to follow. And if you follow those rules, I think that's your protection. But there are a lot more rules that you have to follow in property management necessarily than in other fields of real estate. So again, all of this is doable, right? A lot of it is really off of instinct. So let's talk about some significant property management laws. The types of laws, they're changing all the time. And I'm going to tell you, Sandy, we have rent control, statewide rent control now, that was at 1482, that was put into effect by the current governor. And so, they're just trying to get that, the camel under the tent, as they say, I guess, that they wanted to get that rent control throughout the state of the country of California. It's interesting because we do transactions in San Francisco. We have a broker there who is an attorney, and so everything is just by the number. But they're very, very strict on their rent control issues there, and I think the state is trying to model after that. San Diego changes the rules. You've got to know what the rules are. I would be careful because I have people calling me and I say, well, you know what? I'm going to kick that up to council because I can help you with running your business, but I can't help you with giving you legal advice. I'm not going to do that. And so I have a whole host of attorneys that I refer people to that can help. And that's at some point you got to know when to cut them. You got to know when to send them off to council. So what are the implications of those things? And so you could risk, if you break any of these laws, you could risk loss of license. That may be the easiest thing. Sanctions against you. We have fair housing issues, possible federal offense. Remember, if you have a fair housing complaint that sticks or a fair housing complaint that is enforced, it's a crime. Therefore, there's no E&O coverage, right? There are criminal sanctions for that. And by the way, in my talks on fair housing, it's never one complaint. It's almost always like 8, and it's per offense, so it can get really expensive. All right, and so I'm going to give you some hints here in a second. Again, there's my loss of license. Tenant selection, probably one of the most onerous tasks that we do. Screening the tenant. Okay, so I recommend not getting a photo ID until after the decision has been made to lease to the tenant. That photo ID, I know we've had that come up to be, a potential for a fair housing issue, right? I remember having this conversation with Gov Hutchinson. I was chair of risk management last year for the California Association of Realtors, and I said, at some point our purchase agreements, we're not going to have names in there. It's going to be like John Doe, because I can maybe tell the nationality of somebody based on their name, but obviously a picture, I can tell, a lot of things about a picture. And so I always recommend to property managers and leasing agents not to get that photo ID. In the old day, the practice was to get a copy of the driver's license. And I don't know, I wouldn't do that today. I would make the decision based on, the generic, and there's an argument. Do you take the first one that comes in, or do you put them all together and then have the owner decide, or are you making the decision? Most of the companies I work with, they make the decision, not the owner. And so you want to do some things to protect yourself, and you want to stay very current on fair housing. And the Department of Real Estate has upped the game a little bit in the field of license renewal to include more classes on fair housing. And again, remember, we're talking about discriminatory effect sometimes, not necessarily discriminatory intent. It's not that they intended to discriminate, but they said or did something that just wasn't right. And so it had the effect of discrimination, even though it wasn't their intention. That can be just as bad. Okay. All right. So potential fair housing accusations, credit reports. Let's talk about credit reports really quick. So it is a criminal offense, it's a federal offense, to run someone's credit report without their express written authorization. So express and written are the same thing. I just put it in parentheses so everybody understood what express meant. But you have to have something in writing from them that authorizes you to run their credit report. Okay. All right. So I can tell you the San Diego Association of Realtors has a relationship with a TransUnion called SmartMove. We use that in our office. And so one of the reasons is because we do leases. And so what we'll do is we'll have the tenant will fill out an application with us. And I'm going to show you the application in just a second, but they fill out the application with us, and then they go to the website, and then they do all the work with the tenant screening organization. We don't get a copy of the credit report, no nothing. The owner gets a copy of it. But the screening organization gives the owner kind of an idea of whether or not, what are the chances of success with a tenant. Now, I'm going to tell you from personal experience, I had a tenant in my office who was going to lease one of my properties a couple of years ago, and they had 16 pages of bad news. I mean, their credit report was trashed. And so, they said, we really want to rent the place. I said, all right, come on into the office, we'll talk, right? Because you can't base your decisions on all a credit report, all your Fair Isaac scoring is a propensity to pay. Okay. It's not an indication necessarily of whether or not they're going to continue to make those payments. And so I've had really good tenants go bad. I've had really bad tenants be good. This was an example of 16 pages of bad news. I told him, I said, I think I'm going to have this bronzed because I think that's an amazing credit report. I just can't show it to anybody, but it was amazing to see something that trash. Well, the tenant came in and spent hours with me, explained every single item on the credit report. And so what it turned out was he was from a small town up in north of LA near Carpinteria. I don't think it wasn't Carpinteria itself, but it was up north in that area, and it was a family-owned town, and they didn't want him marrying the daughter, and so they went and got married anyway. And so the family set about just trashing this guy. And it was and lovely couple. If I tell you, they were in my office and they explained everything. And I took them. Probably one of the best tenants I've ever had. They sent me referral business. They sent me people that wanted to sell their houses. 9 months into the lease, they had to break he loses his job at the Toyota dealership. I wrote a letter of recommendation for him on the new landlord up in San Bernardino. I'd rent to him again in a heartbeat. Okay. So make sure that, and then I've had tenants with absolutely great credit, and we just did not get along. Tell you, credit reports not necessarily an indication of whether or not they're going to be a good tenant. All right, it's just a propensity to pay. Okay, all right. So enough about that. But you must have something in writing, and on the lease rental application form, and we've changed the name on it a little bit. But on the lease rental application form, we actually have permission to the tenant gives us permission to run their credit report. Now, a couple of things I want to tell you. One of them is you must have a separate credit report for each applicant. All right. And I say that because, in the old days, we used to have we'd have the husband and wife. And so we would have each of them fill out the same page. Well, the law came along and said that's discriminatory practice, right? I mean, it's you need to have a separate one because not all of our couples are married couples. There's a lot of things going on, right? So you got to have a separate credit report for each applicant. You have to have a separate application for each applicant. All right, over the age of 18, and this is how California works. occupying the property for greater than 14 days. The law treats them as a guest, but anything over 14 days, you got to have them on the form. And so we see, as a matter of practice, we see this. We see the really good tenant comes into the office and fills out all the paperwork and does all the stuff. And oh, thank you so much. I can't wait to move in. All that kind of. And then in comes the trailing, the one with the really lousy credit. That's why your lease agreement in California pretty clearly says that everybody has to be on the lease that's over the age of 18, which means we're going to run everybody's credit. And I've taken people where they had one had great credit, because that's always the one that comes in the door, and then the one that didn't have great credit, we just have a conversation, and I sit down with them, and I have I have this rule. I say, your rent is due on the 1st. I serve you on the 2nd. And people look at me and they go, that's pretty harsh. And I go, don't be late. The rent's due on the 1st. It's not due on the 2nd. I'm going to serve you on the 2nd. And so, we're going to begin the process, because I'm thinking you don't, want to pay your rent. And so, I got to tell you, it may sound harsh. I've had tenants 15 years in the same place, multiple tenants for 15. I've had tenants move from one of my places to another one of my places just so they don't lose me. So, I take really good care of my tenants, and you need to do that as well. If something breaks, fix it. I'm going to have somebody there. If it's my property, I'll have somebody there and before the day is over. Again, assuming the tenant didn't do it, right? But anyway, anybody occupying the property over 14 days. Okay, everybody good with that? So I've always said, if you want to understand real estate, the forms will teach you. Rental and management agreements. So let's talk about some of that. So what types are there? And so we've got the property management agreement. That's the PMA. And so I do want to take a look at that. Okay. Because actually I want to show you just really quick. Here's some of the other stuff I'm going to share with you later. So this is the DRE articles. So I've saved, because that's how I am, right? So I've saved a whole bunch of DRE articles. Almost all of the audits all have something to do with the property management, trust accounting, and things like that. But most common enforcement violations, opening a trust account. They've actually got an article on, I remember, because we went to Wayne Bell and we said, we really can't get a trust account because we're not a trust. And so, there's that legal thing going on. And by the way, Wayne Bell's an attorney, he's an Esquire, right? And so, again, I think one of our most prolific writers, although I do like Macaulay also, the current commissioner is kind of a neat guy, but how do you open up that real estate broker trust account when you're not a trust? And so he went down and tried to open up a trust because he just wanted to know what we were telling him. And so, we get into all this. And so here's this whole great big documentary on how to do that. And I'm just realizing I'm working with somebody right now that I probably should have sent this to, but good article on it. When was this? This was actually written when he was still commissioner, but let me see here. If doing the above still does not work, consider using another bank or depository. So, there are people out there that do it. You may have to go with a big name brand bank, oh, shoot, I'm talking and I'm not even, I hate it when I do that. Hang on a second here. Let me get you to what I'm talking about. So this is the article that Wayne Bell penned. And so I'll send this to you if you want it, but how do you open up that trust account when some banks don't have that ability? Okay. So I'm not going to open up all of these, but I just want to show you a couple of them, like the RE 855, my trust fund status report, things like that. Again, these are all forms that the Department of Real Estate, listen, if they create the form, I'd probably use the form. Okay. So this goes into all this report information, all that kind of stuff. And again, you could, if you're not into doing forms, then you could probably hire somebody that'll do it for you. Question. Oh, shoot, I've done it again. Hang on a second. Let me pull the form up while I'm answering the question. So this renter's insurance is not required in California. That's a really good question. The only real insurance that I'm aware of that's required in California is automobile insurance. We don't even have a requirement to have hazard insurance. There's no law. The problem is that people that don't have loans on property, because a lender wants to make sure you have insurance, but there's no real requirement by law. So I think it's a good idea. You're about to say it here, and that's the RLLM, which is the new name for the residential lease and month-to-month rental property, advised or recommended only for tenants to obtain insurance. So in our agreements, we require it. So should the tenants and you're going to pick out on college students, and thank you for that. So folks, you all know I'm reading a question here by Anonymous, who I think, if it is who I think it is very prolific with this. But so should the tenants, college students, opt to waive this renter's insurance? Is there such a CAR waiver form? I'm going to say I'm going to require it. So it kind of trumps that whole thing, right? No pun intended. But I had five college students who wanted to rent a 4-bedroom house owned by my former business partner in Carmel Valley, and nobody would rent to them because they were college students. Why not? Right? I love college students. They stay with me forever, right? Because nobody else will rent to them. So anyway, we did all the things that we had to do. 4 girls, 1 guy in a 4-bedroom. None of them were coupled up or anything. That was kind of weird, but okay. All right. Not my thing about how they handle their housing. But there is no waiver. But anyway, so we took them, understanding that they were more nervous than I was. I was fine with them. They were, by the way, they were all graduate students, so it just kind of worked out that way. But I don't care. I like students. I'm going to take care of them. Military, absolutely, I'm taking them. Right? If I've got a problem, I'm calling the CO. Okay, never have a problem. And by the way, they return the property cleaner than what I give it to them, and I have it professionally cleaned. So anyway, these girls moved into the place. They went around to the neighborhood knocking on doors with cookies. They took cookies to all of the neighbors, the cookies that they had baked, to all of the neighbors. And they said, here's the thing. We want to be a good neighbor. If you have any problems with us, would you please let us know directly? And so because I'm getting this report from the neighbors, and the neighbors said, we asked them, what's the problem? They said, well, because if we do something, we don't want to have to deal with Mr. Burke again. So I don't know. I'm pretty good with tenants, but I like I said, I have tremendous amount of respect for my tenants. I take really good care of them. What does the owner care about? The owner cares that the rent shows up on time, whatever that is. It's usually the first of the month. Rent shows up on time, and I counsel all of my owners that if something goes wrong, you need to get that taken care of right away, because that's a mutual respect back and forth. But for my tenants, the rent's always in on the first. And let me mention the rents just really quick, because that creates some problems. So remember that when you have a lease agreement, the lease agreement is usually for term. So it's usually a year, let's say a year in most cases. So the lease is for a 1-year lease. So the tenant owes, so if it's $1,000 a month, it's $12,000 a year. The tenant owes $12,000. Is everybody okay with that? Okay. The fact that the owner takes the $12,000 in monthly payments is an accommodation only. All right. And so the if the tenant leaves on month number 3, then they owe the other 9 months. At least that's the way our leases are written. Okay, so they still owe the other 9 months, right? I mean, the owner can't let it sit for 9 months. They've got a duty to mitigate damages, but attempt to find another tenant under the same or similar circumstances. Fill the shoes, so to speak. But the tenant signs a lease agreement, and they owe the entire amount. The rents are just collected monthly. Now, here's the caveat on that. So I've had tenants who have come to me and said, I'm going to give you, here's the check for July, here's the check for August, here's the check for September. And so just cash them as time permits. Well, one of the problems with that is that the first check is a check to go towards the rent, but all of the other checks become promissory notes. And so you want the protection of the NSF laws, okay? What did I do? Okay, you want the protection of the NSF laws. So I wouldn't accept checks that way. Now, if the tenant wants to give you a check for one check for July, August, September, okay, that's going to be an advance rent. But when we talk about security deposits in a minute, you're going to see you got to be careful about that. This is one of those classes I wish was, I mean, literally, I would teach this class for 17 weeks, 3 hours a night, and it wasn't enough time. So I'm going to, but thank you for asking that question. It's a really good question. So everybody see the form I'm looking at? This is my trust fund status. And by the way, let me show you where this stuff is, because again, I'm going to take us back over to the Department of Real Estate. Here are their audit forms. Okay, so they have them, and it's really easy. I think you can see it. Yeah, you can see it up at the top, but it says dre.ca.gov/forms forward/audits.html. And here's the forms. This is some of the forms. There are more forms, but the best way for you to find the forms is to go up here where it says forms, and then click on that link, and then you've got all kinds of stuff that you can do in here. Okay, here's landlords. Landlords one's not really very helpful. There's the notice of intent to foreclose. I think they must be updating that part of the website, but just be aware under forms, this is where you're going to find most of those forms, unless you know the numbers. And then if you know the numbers, that makes it a little bit easier for you. But I wanted to show you that, and it was about time that I did that. So let me get us back over to my, so again, in here, I have the DRE articles, all the landlord brochure, all of these things that I'm happy to send you. The forms, which I'm probably not going to send you the forms, but I'll send you my template, right? Because, you see that these were all done on March the 6th, but we just updated a bunch of stuff we updated like 67 forms, okay? A lot of the forms were just, a word here, word there. Like they still haven't fixed the purchase agreement, paragraph number 11M, to say, that it's the solar power system. And, I give them grief about that all the time. When are you guys going to, because otherwise we're selling, Neptune and Venus and Pluto, or Pluto, we get into an argument whether that's a planet or a satellite, but we're selling planets, right? We're selling a solar system versus a solar power system. So here are all the forms. You'll notice the residential hazards forms, the residential environmental hazards, required, by the way, in both sales and rentals. And so on a sales transaction, we usually get away with it. We use one of the natural hazard disclosure companies, make sure that that natural hazard disclosure company is giving them the environmental hazards form. The one that we use does do that. They do everything, right? So really there's not much else left for us to do. But on the rental side of things, you got to know to create this. And when I show you my template here in a second, you'll see what I'm talking about. Okay, so I have the forms for you. I have the inspections that we want the tenant to do, and these are red line versions. So the move in, what used to be the MIMO form, which was the move in, move out, has been bifurcated into two forms. Now it's the move in inspection form, and then it's the move out inspection form. And so you want the tenant to have it. You want them to protect their deposit, and you want to know when things are going wrong, right? So that's what those are all about. And then I have notices to the tenant, and again I broke down all the forms and created this entire library for you, which I'm going to solve the whole thing by taking you to my my happy place. Where is it here? Realtor secure transaction. I'm going to go ahead, log in. All right. I want to show you my I like doing the current forms, and I was so excited. I think I told you this already. I was so excited that they did finally updated the forms, and I really have my hat is off to the committee. I mean, it is a lot of work. So I'm going to go up here to templates. I'm going to click on forms and checklists, and I would advise you, if you are doing property management, I would advise you to create templates, okay? Because you want to treat everybody the same. You want to treat everybody equally, everybody fairly. You don't want to any kind of an accusation that you did took somebody that before them, that kind of thing. So here's my property management template. I have my lease template also, but let's take a look at my property management. I have my buyer offer, my seller listing. I have templates for everything. Okay, and again, send me an email. I am happy to share with you. Okay, I don't, I'm here to help. If I frequently get hired by brokerages to update their templates, in which case I do charge for them for that, but I'll help you just because you were here today. Okay, so let's take a look. This is my template. All right, so how does my template work? I've got my PMA, which is my property management agreement. We're going to dig into that first. I've got my lease agreement. So this is what happens when the property management agreement is successful and I've secured a tenant. Then I have my notices to my tenant. And here's all the notices in here. And again, these are all current. See this 623, 623. Again, as a leasing agent, I won't do these, but as a property manager, I will. And then I have my disclosures and my advisories. So it's pretty simple, okay? And if you don't know how to use a template when you create a transaction, I just did the webinar, was it last week? It's uploaded onto YouTube, or I can, if I haven't done it, I will update it. So question, oh God, Judy, thank you. I am 12 years of college down the tubes. I do this frequently. I'm sorry about that. So where is it? Here it is. Judy, thank you. That really helps me out when you, of course, everything in caps means you're shouting, but I appreciate it. Thank you, Judy. So here's my templates. Okay, so I went into Zip Forms. I do everything under the template button. Let me take you back just to click. Thank you, Judy. I'm so appreciative that you told me that. So here's my property management template. Here's my lease template. Here's my buyer offer template. Here's my seller listing template, right? I have a template for the buyer representation agreement. I've got templates for everything. So I'm going to open up my property management template. And then again, I have my property management agreement side of things, which we're going to dig into. I've got my lease agreement. That's the other side. That's what happens when the tenant comes in. Then I've got my notices to the tenant, and I've got them all broken down for you. And they're all, like I said earlier, 623 versions. You know, the tenant flood hazard disclosure, which, as you can tell by looking at it, there's a minor typo in there. I got to remember to tell them about that. But sorry. Thank you, Judy. I know you're not on. Thank you. So I appreciate you more than you know. So anyway, so look at disclosure, disclosure, I guess is what that word is. But, you know, I get the intent, right? I understand what they're trying to say, but look at all the 623s. We did a lot of stuff. So again, because I created a template, they updated all my forms for me in the template. They won't touch a transaction in progress, right? They don't want to mess up what you've done, but they will they will fix your template. They're not going to add new forms, but we already know we've only got what, 4 new forms. And I'm just trying to think off. If you want to know what forms are new, go up here to all forms. Scroll down to where it says all, click on the button, go down to form update for 623. So in December, it'll say form update for 1223, right? So this is how you always know that the forms have been updated, but here's all the updated forms, right? So I can tell, you know, like my pet addendum, you know, is in there. These are all the forms that were updated. Okay, so that's a lot of forms. So you see how much work I just saved myself. I did just load one myself a minute ago because I noticed that it wasn't in there, and that was the because it was a new form relative to leases. Look at that, my property management agreement definitely uploaded. Here it is. So the RPOD was the rental property owner disclosure. It was a form created. I'm going to show you in a minute, but so I'll just show you. But then the RPOQ was the one you give to the tenant. Okay, so that's going to be the difference there. So here's all my notices to my tenants. I did load it. I cheated. I went in there. I looked. I go, oh, wait a minute. The RPOQ just came out and it wasn't in there. So I knew that it was one of the new forms because under my all forms, the easier way for me would be to go to the website and pull that up. And if anybody wants me to show you, I'll show you how to do that as well. What are the pros and cons of rental, lease, and month-to-month rental? Oh, there's $1 million question. You know, I had Kathy Belleville, who's one of the attorneys for Kimball Tyree in St. John. I used to have her come talk to my property management class, and I just love Kathy. And unfortunately for me, she retired, right? I hope she's doing well, but she just decided after 30 years of doing this that she'd had enough. But she made the comment in my class. She said, I don't do leases. She says, I do month to month. And the reason is because I can get rid of them a lot faster, right? Now, again, remember in San Diego, there are new laws that are in effect, and SDAR's got some really good forms on that. When you go up into here and you click the drop down for San Diego risk management forms, you can see that they've got the residential eviction rent control advisory. Again, I would use the local forms. I'm kind of big on that. CAR creates forms that work kind of across the state, like the big umbrella, but I like using specific forms if we have one specific to San Diego. And so there's my rental eviction and rent control form. I don't think we have not updated that form. That was updated in January. So if you see a local form, I'd probably use the local form, check with your broker, but especially in San Diego, you have some immense member benefits just for being here. Okay, so to answer your question, Kathy would say, you know, I just don't do leases because, you know, because that sword cuts both ways, right? We're stuck with each other for a year. She says, I can get rid of you in at the time it was 60 days. I can get rid of you in 60 days a lot easier than if I've got a lease agreement with you. You know, if I just don't like you, you know, that kind of thing. So I thought that was really insightful, but I've always proposed leases because I like setting boundaries, things like that. But again, she's an attorney and I think she probably intimidates a lot of people, but But at the end of the day, I think that's sound advice. And I think your question is a really good one. Do you want leases? As a property manager, you're going to have leases, okay? Because you got to have contracts that protect the owner. Then after my notices, I've got my disclosures and advisories, my bed bugs, my lease rental. This is San Diego form, by the way. I like the San Diego lease rental mold and ventilation addendum more so than I like the California's. I'm sorry, we have the mold advisory. The mold advisory, by the way, is the most commonly used form in the San Diego Risk Management Library. I just think that's fascinating, and I like that form better than California's. California tends to copy some of the stuff that, well, let's not use the word copy. They tend to create their own forms modeled after our forms. I'm being nice, but here's my housing provider in default addendum, things like that. So, but here's my pocket, my environmental forms that I'm going to have the tenants sign off on. Okay. All right. So that being said, let's dig in. I want to dig into my property management agreement really quick. Let's just take a look at it. Notice in here, I've got my property management agreement. I've got my addendum. I've got modifications of the listing if necessary. I have my RCSD, but we've made some changes. Notice it's the RCSD HP. So it's no longer the L, it's the HP for housing provider. Our fair housing and discrimination advisory was updated this month. I'll show you the difference if we get to it. I'll show you what that looks like, but essentially what it is we changed the name of landlord to housing provider. We do the cybercrime flyer, we do the WFA, the wire fraud advisory, for sure we do that. And here's I pulled in the trust bank account record just to show you what I was talking about. When I click on that, it's going to pop up the window. It's going to say, we don't do that anymore. This form has been discontinued. So CAR on their letterhead no longer has the form. They refer you to the DRE website, and that's the list of forms. It's the 4,500 to the 4,699 forms, and that's the location on the DRE's website. And again, if you're a newer company, then you probably want to follow that fairly religiously. As you start to get a lot of properties and you start hiring more people, and you're going to have counsel nearby, probably look to them to see. I just don't know a lot of attorneys that like you using standard forms. Again, contract law, a year of law school, we never talked about the CAR forms. It was a heck of a lot deeper than that was. So I see agents write really interesting things in their contracts, but I was like, really, what are you thinking when you wrote that? I had one that cost the owner $52,000 because of a comment that was made in a counter offer, and it's like, oops, I wouldn't have said that probably. And my buyer happened to be a practicing attorney, litigator, and obviously the agent, our agent as well. So that's my PMA. So let's take a look at my property management agreement, because I want to show you that, and I want to show you the lease agreement. Okay, those are going to be my two big hot buttons, but I also want to show you the rental application form. So with my property management agreement, of course, I don't know how long the agreement's going to be for, but the law says if it's a leasehold interest for more than a year, you have to have agency disclosure. I don't see any harm in disclosing agency. I think that is one of the most important things that you do, is disclose agency up front. You're disclosing the concept of agency. This does not create a contract between the parties. Again, I do a lot of trial work on this. 2079, one of my babies, and I can tell you, I have yet to, and I'm echoing an attorney that I had talk in one of my classes. I have yet to have a broker explain agency to me, and I am grilled on it in court. And so, and I was asked by an attorney just recently to do a class for SDAR on agency, and I said, they're only going to give you an hour. I don't know if I can do it. So agency is a very complicated subject, right? So we have to disclose the concept of agency, but then because at that point we know we're single agency, but later on when the offer comes in, we may end up being dual agency, and so changes the game a little bit. But one of the things I want you to notice up here at the top, notice the revision date is 12/21. There was a revision date back in 12/18 when we first started changing. CAR essentially changed the language in what was 2079. Part of it being that we have a seller's agent rather than the listing agent. We have a buyer's agent rather than the selling agent. And the DRE knew it was confusing to us. It was clearly confusing to our clients. So CAR went in and essentially rewrote the law. because it's a law, right? It's the one you're subject to. So you should know 2079 if you really want to get into the weeds on that. Notice here's my fair housing discrimination advisory. Notice the date on that one is 6/23. I'm going to go down in here to where is it here? Judy, help me out. Here we go. Landlords. Which again, it shouldn't say landlords, it should say rental property owner and housing provider. So I'm sure we're going to fix that at some point. I got to make notes of these things because I don't want CAR. We need to make sure our forms are thorough, okay, and complete. So it's just one of those things that got missed. To the last I checked, they still hadn't updated the purchase agreement. So okay, so that's my fair housing. Then we get to my property management agreement, not binding on the broker. This is really important. Unless signed by a broker or the office manager on the broker's behalf. Okay, so you as the agent signing the property management agreement does not bind the company. Okay, real important. So this is revised. This was just revised in just a couple of days ago. All right, so 6 days ago. Clock is ticking. We're already working on the December changes. So I just threw in some numbers here. Property management RPO now for rental property owner rather than landlord. Again, they're still doing some tune-up. A lot of this was tune-up. The 67 forms that they changed were all tune-ups. Okay, so I've got my RPO. Again, this is the agreement between the owner of the property and the property manager. So watch out for that state exam question that says, that gives you the option of tenant. Most people answer tenant. No, no, no. Property management agreement is between the owner and the property management company. It's nothing to do with the tenant. Okay, all right. We've got, thankfully, we've got our beginning and ending date, which, the law likes a date certain. So we have a beginning date. You must have that date. And again, I'm not going to do a contract law class here. I just want to go through some of the highlights, but it's also got an ending date. Something that bothers me about the buyer representation agreement is that they've got end days. And I know Ed Estes and I were working on, what did you guys do that for? So, and they never answered us. So, question, some property managers do not update or resign a PM agreement. Or resign. Oh yeah, can you review? I think you're out of contract. We're going to see there's a provision in this agreement that talks about renewals. But thank you, Judy. That's a really good question. You need to have a current contract. If you're a property manager, you need to have a current contract with your client. So if your contract with your RPO expires, you need to up the contract and be careful. I know that the DRE right now is talking to people that are doing creating lease agreements, but then having the owner sign a listing agreement that takes effect at the end of the lease agreement. And I'm not on risk management anymore for San Diego. I don't know why not, but okay. And I can tell you that they're investigating those where you get a listing agreement that starts a year from today, that kind of thing. So really be careful about that. Okay. So anyway, my beginning, my ending date shall continue as a non-exclusive agreement. We're going to make it exclusive in a minute, that either party may terminate by giving at least 30 days written notice to the other. I don't work that way, so I'm probably going to check the box that, wait, where did it go? I lost track. Any additional property. Remember, I might want to get out of the agreement, but okay, after the exclusive term expires, this management agreement shall continue as a non-exclusive agreement. I don't want that. I'm going to sign, remember that modification? Remember my modification form right here? My modification form, I'm going to extend that expiration date of that agreement. Okay. All right. So I'm not going to operate off of an agreement that's expired. I'm not doing that. All right. Especially because remember, when you define your duty, you limit your liability. Something I made up, by the way. I was really proud of that. Okay. All right. So early termination, no. You're putting too much into this. Either party may terminate the agreement at any time for cause. Okay. So cause, like the owner decides to open up a meth lab in the property. I'd probably steer clear of that one, right? But if cause might allow me to do that. It might let me get out of that. Property manager acceptance. So property manager accepts the appointment and grants and agrees. So we have to have our granting language. I agree to do this. If you agree to do that, it's not has anything to do with compensation. All right. use due diligence. This is what I'm going to do. Furnish the services at the reasonable discretion of the property manager. Authority empowers the RPO, grants the property manager at the RPO's expense watch that, advertise rental lease direct payments. I'm again the electronic payment by the tenant. I don't like tenants being able to direct deposit into the account. I don't like that. I know a lot of people that's really fashionable to do that. I had one of our brokers say to me, Kevin, you got to get into the 90s. I'm not getting into those 90s. Okay, I'm okay with it. I don't text with clients, that kind of thing. But those different things happen. Remember, you have protection of the NSF law if the check bounces, but you don't have that same protection on a wired in fund. Okay, so all right. Plus, I think it opens up holes in security that I don't think you need to have. So the agreement shall not exceed a certain amount of time, years. I doubt you're going to do month to month. What's the authorized lower? Unless the RPO authorizes a lower rent shall be this figure, and it's going to be based on a variety of factors. If the RPO permits the tenant to pay rent by direct deposit, see, here we go, right? RPO shall discuss with a landlord tenant attorney. Again, what do we call those? QCREA, Qualified California Real Estate Attorney. Okay, we want them to talk to a QCREA, the implications of doing so. And I am apparently going to be chair of the Expert Witness Forum starting next year in California. And I can tell you I have fascinating conversations with attorneys, like-minded people as myself, and you'd be really careful about this, okay? So there's other things that happen. If the tenant defaults and an eviction becomes necessary, you may have some challenges with that. You're going to have to absolutely hire an attorney, I think, for that. I don't think you're going to handle that yourself. Tenancy termination, so sign and serve in the RPO's name, those items that are required to get rid of the tenant. Repair and maintenance, we're going to talk about cost on that in a second. Reports, notices, and signs. Broker and third-party vendors. This paragraph actually gives the housing provider, the property manager, the ability to monitor, control the activities of those contractors that the RPO has hired. Okay, so we kind of want that, right? We don't want them going in on their own and we don't know about it, those kinds of things. Expense payments, this is the good stuff. So expense payments. So notice in here that the property manager, the housing provider does not pay for stuff. They're not supposed to pay for stuff, okay? But so what are you going to have? However, for the following items, the RPO shall make direct payments unless the broker is checked or it is otherwise agreed. So in this case, the RPO pays property taxes, pays the mortgage payment, pays the HOA dues and fees, pays the property insurance, pays utilities, unless you check the box. I don't know. It depends on how much control you want to have. But again, if you're going to be paying these things, then you're going to need to make sure that the RPO has more than enough money to put in the account to cover those expenses. Okay, remember, you don't pay anything out of your money. All right, and we have that in here as well. I'll show you that in just a second. So page 2, limitations on payments. You cannot spend more than this amount of money without approval. Most of the ones I see is like $5,000. Obviously not required for individual expenses. Security deposits. So this talks about and again, I didn't intend to do a contract class here. Let me pull out some of the highlights. RPO shall be responsible to the tenants for return of the security deposit and all interest due, assuming that the RPO has the money, right? Trust funds, again, same kind of stuff. Property manager not liable in the event of bankruptcy or failure of a financial institution. Reserves, how much money is the RPO going to leave in the broker's trust account for purposes of handling the property? And it needs to be a sizable figure. Disbursements, here's the order of disbursements. So disbursements first to the property manager. So you get paid first. It's a beautiful thing, right? Then to all other operating expenses, right? And then to reserves and security deposits held by the property manager. And then the balance, if any, goes to the RPO, okay? Distribution, again, is it going to be monthly or quarterly or yearly or what? Statements, here we go back to that. I said this in the PowerPoint. It's going to be quarterly or some other time. I'd probably do monthly here. The default says monthly, right? I'd probably do monthly. monthly, because that way you know you're watching your books. But I think if you don't do these things except quarterly, I think you're just asking for trouble. Okay. Property manager's funds. This is very important. Property manager shall not advance property manager's own funds in connection with the property or this agreement. So now you've set it out in writing that you are not going to be paying for anything. KLA mail forwarding, and there are no circumstances as the property manager responsible for mail forwarding. I just had this call the other day. They said, we keep getting mail for the previous tenant. Did you notify them that you're not going to keep their mail? Yeah, they have a responsibility to do a change of address, right? I mean, Linda, the last ranch that she bought, she kept getting the mail for the previous owner for 6 months. And I said, tell them you're not going to do it anymore. I mean, she's taking pictures of it, sending it. They were driving over, picking it up. It's like, put it in mail forwarding. Okay. All right. Rental property owner's responsibility. So this is what all the owner of the property is still going to be required to do. Okay. And we're going to require them to fill out that RPOD. And I'm going to show you that really quick. But now we've added and the RPOQ. Okay. That's new to the contract. All right. New to the agreement. All right. We'll get down to that. You get to indemnify, defend, and hold harmless. I love those words. The property manager. Of course, unless the property manager, commits a crime, maintain the property in human habitation, that kind of thing. Carry, so to answer one of your public and premises liability insurance in an amount no less than $1 million. All right. So depending on your area, like I handle some companies in Coronado, I think that number needs to be significantly higher. All right. If you fail to do so, you authorize the manager to get it, and that's going to be expensive. Let me see, pay late charges, all that. The RPOs, representations, tax withholding. This is what gets us. Okay. So RPO, if the RPO, that's the owner of the property, is not a California resident or a corporation or LLC qualified to conduct business in California, RPO authorizes the property manager to withhold and transmit to the FTB 7% of the gross payments that exceed $1,500, which is in a calendar year. Oh yeah, I think so. So you want to avoid that if you can. They need to talk to tax counsel. Do not help them with that. I always get the kick out of, I told them that all they had to do was do this. If you are engaging in helping someone avoid their tax liability, you could be going with them for tax fraud. I wouldn't do that. I'd hire somebody who is qualified. They need to hire them. You need to have somebody for your own account, but they can always fill out the 589. I would not help them do that. I don't know. I know where my boundaries are, maybe better than most. Okay. So, and that's on the state level. Then on the federal level, of course, we're withholding 30%. I don't want to withhold, right? I don't think any of us do. But if they are subject to withholding, then you're going to have an obligation to do it. And then paragraph number C, one of my favorite paragraphs, broker has a legal duty to report rental income received to tax collection agencies. Okay, so compensation, and I'm just going to talk about this really fast. Compensation. So this is all the stuff. If you don't check the box, you pay for it. Remember? So if you want to get paid for management, that's one fee. Renting and leasing, another fee. Evictions, that's in addition to attorney's fees and court costs, right? I mean, they've chosen to own property and rent it out. They're going to take some heat, okay? For preparation, pre-litigation, right? To perform an eviction. So all these are separate expenses. So, line it up, figure out what it is that you're going to be spending money on. Again, all that's subject to negotiation, but I'm going to tell you, almost all the companies I'm aware of right now are all charging these fees. So, but you got to put it in there. If you don't put the fee in there, you can't collect it, okay? So, what else? Property manager, blah, 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 blah. You like the way that the words are squeezed together? You think they could have just put 4 up here on this line? They got to go do some, that's just my OCD thing, but there's some tuning up that needs to be done. Okay. Agency relationships, of course, we have to discuss that. Security and insurance, attorney's fees. So big changes coming with the contracts in California. And part of the reason is that we're trying to discourage litigation, right? So in any proceeding or arbitration, either way, the RPO and the property manager are each responsible for paying their own attorney's fees. In the past, you'd hire this big high-priced attorney, and then I gotcha. No, today you hire whoever you want. I'm only paying mine, you pay yours. So that's a provision that's kind of taken the industry right now. Hasn't hit the RPA yet, but it's hit most everything everything else. Dispute resolution, mediation by default, always. That's the way it is in California. Okay, we're going to mediate first. Obviously, there's some things that are not subject to mediation. So like some matters that are excluded from it, equal housing opportunity, always modification of the agreement. So understand that this agreement says that if you modify the agreement, right, you give the owner 30 days notice. If they object to your modification, then they can either rescind the modification or allow the RPO to terminate the agreement. So if it's that big a deal to you, you can get out of it if they let you out of it. Okay, if you do get out of it, then no cancellation fee. Here's a bunch of stuff. All the rest of this just legal stuff. I want to move on. But now we have our RCSD. Remember what it was? RCSD L is now my RCSD HP. So if you do it on this form, you don't have to do the separate form. And then the RPO, I'm sorry, what did I do here? Yeah. Then, but if it's an individual, then you fill out this part, and then there's the company name and all that happy stuff. Okay, everybody good with that? Now here's that RPOD. Okay, and this was the original form that CAR put out, but they told us this is between you and the property manager, the rental property owner. It is not to be given to the tenant. Okay, all right. Now there's a little bit of that's going to change. So intend to be provided with a lease listing or property management agreement and with a residential lease. Okay, so what does it look like? Looks like my SPQ. I like the SPQ. It says right here, some of it's incorrect, but okay. There's my qualified California real estate attorney, all right, my QCREA. But I've also got down here my statutory disclosures. So I think they changed that on the RPOQ. But anyway, statutory disclosures, things like that. And then death on the premises, which, Civil Code 1710, which, seems not to get addressed, needs to get addressed, right? Anyway, that's that whole thing. And then we have the CCPA, which was updated in December, and a good revision of that. Okay, so let's take a look again now. I want to look at my, that's my property management agreement. I'm not going to go through each of the individual forms. I want to look at my lease agreement. So anonymous over there, let's take a look. I'm going to pull up my lease agreement. Let's go to a full screen. Why isn't the agency disclosure the first document? Well, because we don't know if your lease agreement is going to exceed a year. So no requirement to have it. I still think you should, but you can always add it to it. I've added it to the template. Because I'm just going to do it. I don't care if it's for 2 months, right? So residential lease or month-to-month rental agreement. Again, we changed the name. Again, we've revised this 623. And let me fly through this because we were going to run out of time. I want to give you some resources to go to in addition to the packet I'll send you if you want it. Premises, personal residence by the following named persons only, and this is how you take care of the trailing lessee, right? The one that shows up later. No, here's my anyone in the premises other than those listed are considered a guest. Guests are not permitted to stay more than 14 days. Everybody good? I told you this before. 14 days, that's the legal thing. Without housing provider's consent. I want to pull their credit report. I want them to fill out an application, and I want them to be on the lease agreement. Otherwise, I treat them differently in an eviction than I do if they're on the lease agreement. So if they are not on the lease agreement, then I have to serve them individually, and I may not know who they are, that kind of thing. Okay, so so again, I have my option, my month to month. I'm going to go back and take a look at your question, but I want to make sure I answer it. So waiving insurance, yeah, no, it's not an option. So I can do a month-to-month lease. Again, for real estate agents, they like the longer term lease. Why? Because then they get paid based on the gross rents. That's on the leasing side of things. But on the listing, if I'm a property manager, maybe I'm okay doing the month-to-month. My experience on a month-to-month is you always get notice at the worst possible time, right? They give you notice at October that they're moving out November 1st, and then you got people that won't move on Thanksgiving. Nobody moves on New Year's Eve, and so maybe you sit vacant for a little while. So I like to control the exit strategy, so to speak. So terminates on such and such a date, 5 p.m., whatever you want to do. Rent shall be this amount. Rent is payable in advance on the first of the month. I always check this box and I put NA. There is no other day of the month. It's the first of the month. I want it on that day. And guess what? It is delinquent on the next day. Okay. So shall be prorated. I like that clause too, by the way. The rent. So if they move into the middle of the month, then they pay a month and a half, and then they start paying regular monthly rents on the first of that following month. So they pay 6 weeks, and or else don't move in the middle of the month. Okay. Payment. How are you going to take the payment? And then who's it going to go to? I think it's going to probably go to you if you're the property manager. And then when are you going to accept the rents? What happens with that NSF we talked about earlier? Housing provider may require tenant to pay rent in cash. I wish we had that rule back. I had a tenant, it's usually the first check is good, all the rest are bad. So, I've had this happen. I had a tenant I took in, felt sorry for them, didn't pay rent for 6 months. I finally got a court date. This was in Arizona, property I owned in Arizona. She shows up in court with a newborn. And so I thought, oh God, I'm cooked. They're going to own the property. It was my first rental. It was like 35, 40 years ago. And so I thought, oh God, that play the ace card, right? You got the baby. And so the judge said to her, why didn't you pay the rent on the first? And she says, I was having a baby that day. And the judge slams the gavel down and says, you could have had somebody else take the rent in. And it's like, okay, good. I feel better about the legal system at that point, but boy, I was sweating that one. So again, you can require 3 months rent in cash now, no money orders, no nothing, whatever, cashier check. I want to talk about your deposits. They're very careful about, you never say first and last on the deposit, because then the tenant thinks that they don't have to pay the last month's rent. But you're going to have some limitations on how much money you can collect up front. So you all know you got 21 days after the property is vacated before you have to give the tenant back their deposit or an accounting thereof. Okay. And so I wouldn't miss that time, although I've seen people go 28 days and not be held accountable. But all right, the legal system says 21 days. Clean the premises. By the way, that's broom clean, unless specified otherwise. Our addendum says professionally cleaned, including windows, because that's how we gave it to them. Okay, what else? Security deposit will not be returned until all the tenants have vacated. And this is something I wanted to tell you. If you're going to take tenants, you want them to, one check. I don't want 5 checks. All right. I want 1 check, because invariably what happens is 3 of them are able to pay the rent that month. The other 2 can't. No, I'm getting rid of everybody. Okay. So, jointly and severally liable for that lease agreement, 1 check. And by the way, when they're leaving the property, I send a check to the person that wrote the original deposit check, unless I have everybody send me something that says we're okay with dispersing it individually to us. Okay, so no interest will be paid on security deposit unless required by local law. And then I want to get into the issue, the maximum amount of security deposit. Okay, so I get this question a lot, right? Cannot exceed 2 months rent. So an equivalent of 2 months rent for an unfurnished property, an equivalent of 3 months rent for a furnished property, in addition to any rent for the first month. Okay, on or before initial occupancy, not first and last, right? So you have a limitation. So up to 2 months rent. This limitation does not prohibit the payment of advance rent, but it has to be a minimum of 6 months. And I've had that happen. I had a judge I was representing, bought a lot of property from me. Tenant comes to us. They had a UD, an unlawful detainer, a month before, and it was a couple doors down. And so I said, why would we take you? And they said, well, because it was a conflict between myself and the property, the owner of the complex, right? And I'm like, really? They said, yeah, the place smelled like cat urine or something. I said, well, why didn't you pay your rent? This person paid a year up front, by the way. And so I said, I guess I don't get it. And you know what they said? It's the principle of the thing. Has anybody else ever heard that? It's the principle of the thing. I'm like, oh my God, man, you torched your credit. Okay. All right. So minimum of 6 months. Otherwise, it's equivalent of 2 months or 3 months, depending on the furnishing situation. Everybody okay with that? All right. Paragraph number 6, late fees. Says 5, I put 0. Okay, it's due that day. I don't think it sounds harsh. I tell them up front. I said it's going to be due on the 1st, right? So it's coming. I have a check sitting right here. Where I lost the check. Our check's sitting right here. Tenant pays the rent. What day is today? The 29th. It showed up in yesterday's mail. And so, but they know I'm not going to cash it until the first of the month. It's only for the 1 month. I'm going to cash it on the first of the month. So my tenants send me the rent early. That's okay. Just not 2 and 3 and 4 months early, unless they want to make it, a big check. Don't send me individual checks. Everybody good with that? But again, there's that respect thing. The tenant, I'll cash their check at the appropriate time on the first of the month. Okay. I got a mortgage to pay. Okay. I have quite a few mortgages to pay. All right. Parking, storage, same rules as a regular lease agreement. We have our water sub meter, gas meter, electric meter. We have all that. Remember, that's all going to be in the RPOQ. And I want to get to that really quick. And I want to for sure show you the lease agreement, lease rental agreement, maintenance, use, and reporting. Again, it's not intended to be a forms class. Pets. Remember that the owner can restrict pets. The complex may restrict pets. Watch out for service animals and emotional support animals. And CR did a really good article on it. I sent it to a couple of property management companies on what they can do and what they can't do. Remember, a service animal is not a pet. You may not charge a pet deposit for a service animal. It is an extension of the person. Okay. And so there's a whole bunch of rules of what you can ask. What's your disability? No, you may not ask that. What does the pet do for you? You can ask that. Okay. I'm sorry, not the pet, the service animal do for you. Okay. So again, and we have a pet addendum for all this. And I like the pet addendum. It's it's a new form. They redid, it's not really even called the pet addendum anymore. It's got a different name associated with it. Where is it here? I like the, I'm going to show you. Here it is. It's the ATCA. So it's the Animal Terms and Conditions Addendum. You didn't know that animals had lawyers, did you? Okay, so here it is, the animal addendum in the agreement. So tenant represents that the animal is a qualified service animal, okay, because you can get them to make that assurance, right? Been previously asked and represents that the tenant or occupant has a disability and the animal is trained to assist. You should read these forms. It's beautiful stuff. It was created by the attorneys. They put together what the committee said they wanted to see, but this is good stuff. You look at this and you realize, wow, I can talk like that. Okay, all right, don't rewrite it. Don't say it. Don't try to put it in your own words. It's right there. A qualified support animal, emotional support animal, right? I mean, this is tough stuff. You got to be really careful with this. I had a broker call me the other day, a year ago now, said, oh my God, I'm in a complete panic, right? Because she had rented to a tenant up in Oceanside and no pets, right? Well, the next thing you know, she gets this call that the tenant brought a pet into the property, and that pet proceeded to kill the service animal of the neighbor. And so they killed the service animal. And remember, the service animal is an extension of the person. And so my question, of course, was that murder one, right? Because the animal intended to kill the service animal. So anyway, needless to say, I referred her to counsel, but whoa, and she still owns the property and everything's okay because the tenant was there without permission. Okay. All right. So that's my pet addendum. I just wanted you to see that. I love that form. I think it's the best, right? So let's go back over to my lease agreement, and usually when I skip around like that, I got to fly fast. So I got 15 minutes, right? So where was I? Tenant's obligation upon vacating the premise. Oh, insurance. So your question was insurance. Tenants, guests, invitees, or licensees' personal property and vehicles are not insured by anybody. Okay, against loss based on these things. Tenant is advised to carry tenant's own insurance to protect the tenant from any such loss or damage. We have to tell the tenant that, because the tenant figures, oh, your insurance will cover it. No, it won't. I don't have insurance for that. Okay. Tenant shall comply with any requirement imposed on the tenant by the housing provider's insurance to avoid an increase in the premium. So I can contact the insurance company, our insurance company, find out what the increase in premium is going to be. I think it's going to be less expensive for the tenant to do it. Otherwise, they're going to be responsible, or we could lose our insurance and then we're going to get rid of the tenant, right? So we check this box. Tenant shall obtain liability insurance in an amount not less than, put in a number, whatever that is. I don't know. I like $1 million. Every lawsuit I ever see anymore has 7 digits in it. So, but naming the housing provider and if applicable, the property manager as additional insured. Yeah, you can require it. Okay, so hopefully I answered your question. Was that anonymous? Yes, anonymous. Yeah. We're going to require it. We do. We're not going to, and we want to see the. And by the way, when we make this condition, they send us a copy of the policy. We're on the policy. If they cancel the policy in the middle of the lease agreement, we're going to get notified by the insurance company. Okay. Water beds. What's the problem with water beds? It creates the same displacement of energy on the floor as a refrigerator does. But all right, I get it. I don't think I've ever seen a water leak. My brother's got water beds, but all right. So I don't think I've ever seen one leak. But all right, even a cat getting on it. Notice one part or the other. You have to fill this out. If you don't fill it out, you're in the cooker. Okay. All right. What else? Mediation again, same thing as before. Here's my attorney's fees provision. Interestingly enough, in the lease is going to be on a lease agreement is going to be not to exceed $1,000. Prevailing party in this case, but keeping the numbers down, right? $1,000. And hey, I'm filling out the form. I'm leaving $1,000. I might change it to 500, right? Okay. Mold and dampness. That's a really good addendum. Notice how we're not even halfway through this form. My bed bugs, my Megan's Law disclosure. These are all the law requires these disclosures. My tenant flood hazard disclosure, again, updated just recently. These are things you must provide the tenant. And by the way, in a flood hazard disclosure, I would on the form itself, it tells you where to find the information. And so we just tell the tenants under all circumstances that it's in the flood zone. Right, because just like my natural hazard disclosure, you can't sue me if I tell you it's in the zone when it's not, but you can sure sue me if I tell you it's not in the zone and it is. Okay, so rest of that's contract law. Termination of agency relationship. This is important. So when does our relationship end? It could be at the occupancy. It can be at delivering keys. It can be at the tenant walkthrough. I like the delivering of keys. It's kind of the old way of doing things. And again, my move-in inspection is now my MII, not the MIMO anymore. The tenant has a right, by the way, to receive a foreign language translation of the lease and rental agreement. Oh, and another thing a lot of people don't know about, we don't create the form anymore. We used to have them, and I asked Gov about it. I said, when did we get rid of all the, we were writing our contracts in 5 languages, right? And here's the list right here. He said nobody was using it. So, all right, I get it. They can have it interpreted. They can have it do all that kind of stuff. I would not be the translator for that. Okay, as a real estate agent, I might understand Tagalog, but I'm not going to be doing that. And then, by the way, the lease agreement that is signed electronically is, if I remember correctly, not enforceable at law, but who knows that, right? I always say the contract is what the parties think it is. So you probably should look into that. Let's see what else. Anything else in here exciting? These are going to be required. These are attached. Legal authorized interpreter translator. There it is again. And then here's my entity tenant and my entity housing provider. There's the brokers, and then I get into my bed bug disclosure required by law. Okay, if the owner is aware of infestation, they may not rent the property out. I mean, these are good forms to read. Here's my tenant flood hazard. Look at the date, 6/23. We just updated it. Okay, in our agreement, I'm checking this box. Okay, I'm just going to. All right, and then I go to the city to the county website. I'll look it up. And there's a reference to it right here. So my hazards, you can go there and it gives you the direction to get to the San Diego look-see. And then I like printing the map and sending it to the tenant. Rent cap and just cause addendum. In most cases, the owner is probably going to be exempt, but you have to tell the tenant that. Okay, so notice of exemption, this is probably going to be checked yes. Unless what? Unless the property meets one of these following 4 requirements. Oh, God, you're not going to let me do it. A real estate, a REIT, a corporation, an LLC. I'm sorry, three conditions. At least one member is a corporation. Okay, so all the rest of that. Good stuff to read. At fault reasons for getting. Again, this is statewide. No fault reasons, just cause reasons, and then you have San Diego law. Okay, fair housing discrimination advisory. Again, we've talked about that already updated. Information on dampness and mold. I think I like this a lot. I'm glad they put this together. I think that's a good form to have. I like to hit the tenant with the, I just want to show you this before I show you the lease rental application. Obviously I have a lot to show you, a lot to tell you, but we're not going to make it. Where did it go? We need to notify the tenant that we are going to do background checks. Okay, and so that's my burn form. I just got to find it in here. Probably passed it. Here we go. Burn form, my BRN form. So notice regarding background investigation reports pursuant to California law. You have to tell them you're doing it. You have to tell them where it's being done. Most of your rental agencies make it so that you are not allowed by contract to give the tenant a copy of their credit report. You must by law give the tenant notice of where they can get their own free report, especially if you turn them down for the credit report. And remember, we have a separate form for that, okay? But we need to let them know we're going to be investigating them. But there's also the denial of rental application for credit reasons. So I don't know, I've had people who've said, I just don't tell them it's for credit. It's something else. We accepted a better tenant or somebody with more qualifications or something. So you can see all this, but the law requires this. So I would be good about that. Okay. So let's take a look at my application form because I want to go through that. This is my LRA. Let's go through that and then we're going to call it a day. Or depending on where you are, it might be a night. But here we go. This is my application rent or rent screening fee. And so my LRA, we updated it in December, just 6 months ago. And again, as I said earlier, each occupant 18 years of age or over. I mean, how many times do we have to say that? And by the way, an emancipated minor, that's a good point, right? So I left home at 14. I was signing contracts. I always looked older than I was, right? Today I'm 96, but I don't quite look that. But anyway, the contract is, contract with a minor is unenforceable. It's voidable at the option of the minor. So whenever you create a voidable contract, there's usually somebody that might want to try to get out of it. But an emancipated minor, somebody who, they've been signed off on by their parents, they've joined the military. There's a lot of ways that somebody that could be a court emancipated minor, a lot of things. So in which case they can contract under the age of 18, full name. They fill it when you send this to them for electronic signature, they fill this out. There's no place on here for the Social Security number. Okay. In fact, the reference to Social Security number is up here. See section 2, paragraph D for Social Security number, tax ID numbers shall be provided upon request from the property owner. I don't want it in my file. Again, I do leases, but if I'm doing property management, I'm probably going to have it in the file. Why do we ask for all this stuff? Why do we make them fill it out? Because we need to know how to attach them if they go bad on us. Okay. So we need to be able to find them and attach them. And so it's an application to rent only, does not guarantee they're going to be offered the premises. Applicant represents the above information to be true and correct, true and complete, and hereby authorizes the provider to verify the information. Again, there's my burn form. Please check the box if you'd like to receive at no charge a copy of a credit report if one is obtained whenever you have a right to receive it. And so what's going to happen normally is you're going to send them that document that says, here's where you get your copy. Okay. So this is my reference here to the burn form. Applicant further. So again, you got to have signature. Otherwise it's against the law to pull the credit. Okay. Again, we use the SDR's vendor, which is the Smart Union. There's Rent Spree. There's all kinds of them out there that are pretty good, frankly. Okay, so what else? You can collect a fee. So the screening fee, and they've upped the numbers. It was like $36. Now it's like $52. Here it is down here, $52. You can collect up to that amount, really essentially not having accounting. We don't collect anything for it. We get our pay from the owner based on the gross lease. But if you charge, you can, after that point, you got to start doing accounting to things. But again, according to the DRE publication title, California tenants, CPI inflation calculator, et cetera, et cetera, et cetera. Okay. So you got to fill all this stuff in. And if you're going to have somebody, if they're going to do their housing fee. So if I click this in here, okay, that's not going to have my drop down. Oh, here it is down here. Type vendor's name here. If you're going to have them go directly to this other party, of course it's not showing up in my template. That's curious. Anyway, it's Smart Union by TransUnion, and again, SDR is they're friends. I don't know what that means, but they're friendly. So. And the application received without the full screening fee, housing provider will notify the applicant the housing application will not be processed. And that's if 2B is checked. Okay. So if you pay the non-refundable, if you haven't paid the fee, they have the ability not to lease to you. All right, but in most cases, like I said, you'll provide the screening information and feed directly to the housing provider's authorized screening service. So in our template, it has that name. I don't know why it's not popping down. Okay, all right. Sometimes, by the way, just so you know, if they when we update the form, sometimes it does delete some of your information in your template. So you always want to, after the update is occurring, remember you got to add forms. If they've got forms for you to add, they won't add a form to your template, but they will update the current forms. But sometimes they obliterate information that you really wish they hadn't done. So you got to go back in. You're the captain of the ship. You got to go back in, double check the forms really quick, make sure that you haven't lost important information. How do we get this template? You send me an email. Okay, I'm good. I want you to have it. Okay, I mean it's work product for me, but listen, I'm proud. Again, remember, make sure you get their signature. All right, and then down here I've got my burn form all ready for you to fill out. Is everybody good with that? Any other questions on any of that? I wanted to cover the highlights in there. Obviously, I spend hours on this. Again, it's a 17-week 3.5 hours a night class at the college level, DRE approved, by the way. But I wanted to give you the highlights. So that's my property management agreement. There was my lease listing agreement. We didn't talk about that. We did talk about the LRA, and we talked about the RLMM, completing the forms, rights and responsibilities of the landlord, rights and responsibilities of the tenants, small claims court, one of my favorite places. I love going to court. I don't understand why, but I love going to small claims court. It's the people's court. The process, the paperwork, the preparation. They've got a small claims court advisor. It's usually a second-year law student. They can be pretty good, but you might want to get good at it, right? Because you're going to be going to court, okay? Eviction enactment, so the process, the paperwork, the preparation, you got to be good at that. Property management, what are my preventative measures? What am I required to do? Analyzing costs, maintenance, repair issues, some key concepts. Once again, as I say, when you define your duty, you limit your liability. Okay, so I want to thank you for joining us, but we're not done. Hold on a second. If you want to view any of our previous webinars, we've got a new YouTube website. I'm going to upload all of this, so I'm not going to email you the video because it's just a monster. All right, but I will email you the template if you send me a request. You've got to send it to me. I'm going to give you my email address again here in a second. Okay, so the new YouTube website, get your QR code reader ready. I just learned how to do QR codes about 3 weeks ago now. Very proud of myself. There it is. You take your phone, you go to your QR code reader, and you take your, you just line it up and it grabs it, takes you straight to a website. Okay. All right. All my videos are there. All right. It's a free public service. I'm doing this only for members of the San Diego Association of Realtors. Okay. My home, my place where I live, that kind of thing. Thank you so much, Judy. We've got you could type in @ Burke Real Estate Consultants Inc. I put the case is not important, but I put the case in here so that you can see how it's spelled. That'll take you straight to the website. You could go to the bit.ly link. And by the way, the reason I'm doing this is because we're going to start loading the forms because I'm teaching these DRE classes. We're going to load the forms to sign up for the class because I'm required to give you a sign up form. And so, I love the DRE. They're very outlined on how they do things, and that works really well for my brain, my systems brain. So save this for later. Here, case is important. It's all lowercase. Please remember, do me a favor, please go there, like and subscribe. It's not going to put you on a mailing list. I've got a whole bunch of people that have subscribed. What it does is it updates you when I update the webinar. When I put another webinar up there, it'll send you a notice, okay? That's all. So please like it, subscribe to it. Education at SDAR, I love SDAR's education. It's a department as well as a committee. So, listen, the people that work there are just the best. I mean, they really care about you, and they want to make sure that they're supporting your professionalism. I have a newsletter, weekly updates. You have to ask to be subscribed. It's opt-in only. I send email. If I send you an email, it's got a link in there for you to click on. You can subscribe yourself. So people do this all the time. They get in there. Please don't unsubscribe. If you want to get out of it, just let me know. I'd rather just delete you out of the account than have you unsubscribed. That doesn't make me look too good. But other than that, I'm here for you. I want you to be okay. Remember what I I always say, if you look good, you make me look good. I want you to look good. I really do. Okay. So it's important to me that you are successful in this business. I think that it's a rote business. We do the same things again and again, and I am here to help you. So thank you all very much for being here. If there aren't any other questions, I'm going to let you go for the weekend. Please have a safe holiday weekend. I know I'm going to be spending it with the FBI, which, oh my God. Anyway, you want to have a party. Yeah, these guys they blow things up. Let's put it that way. Not a lot of drinking, but they sure do blow things up. So anyway, I'm very happy about that. I love my friends in law enforcement. So thank you all for being here. I hope you have a wonderful weekend. Take care for now. And as we say, from my hometown of Del Mar, I look forward to seeing you around the track. Take care, everybody. Bye-bye now.